I'll make another motion. Judge, I've had a chance to read this transcript, and I'd like to draw your attention to a few pages.
Which transcript are we referring to, sir?
The October 4th, 2024 deposition of Dr. Tanya Werner.
Okay. Yes, sir. I have it in front of me.
May I sit?
Yes, sir.
I'm referring to page 38 at the very bottom, line 21. Answer, I need to go through my notes and think about it and process it. But I had other depositions, as you were aware yesterday, so I had to prepare for those and go through that. So I had not had time to process through all of my notes prior to this deposition today. Page 39. Line 2, well, doctor, I'm not trying to inconvenience you. You know, the judge set for October 7th for jury selection. Line 5, she answered, okay. Question at 6, but I don't anticipate your testimony would be until later, you know. Maybe we could discontinue your deposition and then reset it when you've got time to review. Because obviously, I'm not going to want to take your deposition and then you have other opinions that are not going to be covered. Then at 13, Mr. J says, what is your position? Then at 14, Mr. J, conducting discovery after the jury trial starts is completely unacceptable to me, so that's my position. If she needs to issue a supplemental report, or if there becomes a need for a second deposition, then we can address that. But it would be my position that we need to get this done because the state doesn't have any appellate rights once the jury is sworn and jeopardy attaches. Line 23, Mr. Owens, well, you obviously understand my position. I'd like to finish the deposition today as well. But if she is holding out that she may have other opinions and other diagnoses after she has had more time to think, review the paperwork, then obviously that creates an issue. The witness on line 4, page 40. But if that happens, I can bring that forward, and then you can add to your deposition at that point. If my opinions change after having reviewed further. Line 8, Mr. Owens. Mr. J? Line 9, Mr. J, I think you need to plow ahead. This is our time whether the court reporter is prepared to give us a transcript by the end of the weekend, and if something needs to be amended, then she can A, issue a report, and then B, if you need to take a deposition, an abbreviated deposition on the limited subject matter she is not prepared to testify about on today, then we can do that. But the notion of halting a deposition today that is set for 3 hours and then doing a 3-hour deposition during trial, especially after jeopardy is attached, is not what the state would do. Line 23, page 40. Mr. Owens, I'm not suggesting that, Mr. J. I'm suggesting that we just said at the very beginning. I'm suggesting what you just said at the very beginning, which is let's finish. But if she has some supplement, then I would want to take a brief second deposition as it relates to any new diagnoses or opinions. Then Mr. J goes, I think he gets confused about an issue relating to a diagnosis of an adjustment disorder or anxiety disorder. So we get down to the bottom of page 41, line 22, Mr. J. Okay, so on this topic, if something new comes up, then we can address it. But if we have other topics to depose her on, then I would suggest we go on. And then page 42, line 1, Mr. Owens, I agree. And Dr. Werner, just let the state attorney know. I know that you may be, you know, we are on short time. If you do review your notes over the weekend or whatnot and formulate any other opinions, just let the state attorney know and we'll address it. Line 7, the witness, absolutely. That was our understanding. I've been ambushed by a new opinion that I was not made aware of by any kind of report. I was not notified by Dr. Werner. I was not notified by the state attorney, William J. I first heard about the opinion when she testified to it, and I objected to it, relating to imminent threat, the ultimate issue of fact. I move for a total dismissal for prosecutorial misconduct.
Denied. And here's the other reason it's denied. Page 38 of the deposition, specifically that you made reference to, starts at page 21, line 21. The question preceding that is important. Question 14. So, from my understanding, when you just said was, yeah, I agree with general anxiety disorder that she had been diagnosed with. Answer, no. I said it would be generalized anxiety disorder versus adjustment disorder, and that I hadn't had time to fully formulate that opinion out. This entire conversation pertains to those two issues, anxiety disorder and adjustment disorder. Has nothing to do with PTSD, nothing to do with battered spouse.
But Judge, we go on, and I see what she's doing, that she's saying, hey, I got jammed up, I had a deposition yesterday, I didn't really have time between the evaluation and the deposition 2 days later, she had a deposition in between to really think about it, really review my notes. So as a catch-all, I said on page 40, if you have other opinions or other diagnoses after she has more time to think and review the paperwork, then obviously that creates an issue. So yes, that was initially what she was talking about specifically, but I realized what she was saying was she was going to have to reflect on a lot of these opinions. So I expressed...
That's, respectfully, sir, that's not what it says. That's specifically in line with the anxiety disorder versus adjustment disorder. That was the entire topic that was being conversed with. Now, later in the deposition, there are references, as I believe that I identified previously. Give me a moment. On page 59, line 22, question is asked, okay, and do you intend on expressing any other opinions other than what we've spoken about here today? Line 25, no. I will answer whatever questions I'm, moving to page 60, line 1, asked. Page 60, line 11. Well, let me just start with 2 because it gives it more context. Question, well, I'm asking now. I mean, you're the expert. I'm not. You're the one that's evaluated her. You're the one that's given her the test. I don't know the field like you do. You know the field. I understand you've said, hey, I want to think some more about, hey, I want to think about this some more. I want to review my notes. Some more to see if, but in terms of right now, without any further reflection, without any further answer, yes, sir, question, reading of the notes, any other opinions that you think you could express in any form or fashion with all this experience, almost 1,000 jury trial or 1,000 trials you've testified as an expert. Anything else that comes to mind that may be an opinion that you might express in Sarah Boone's case? Answer. Anything else that I'm asked with regard to her diagnosis come into play with regard to her case, I guess? Question. What other opinions do you believe you're qualified to express as it relates to Sarah Boone and the facts and circumstances relating to this case? Anything with regard to her diagnosis, I guess. 61. Of those 4 things we mentioned, line 2, correct.
And Judge, the 4 things were mentioned were related to the anxiety disorder, the narcissism, the battered spouse, the alcohol use disorder, which are in pages 58 and 59. But the overall thrust of that was any other opinions that were expressed. That was in good faith what we were doing. I would have, like I said before, I would have never taken her deposition. Once she said I hadn't finished my analysis and I may need additional information, just like he said the other day, Dr. Harper, if you get those additional medical records, Mr. Owens, about Jorge Torres and give them to Dr. Harper, then I'm going to want to take her deposition again. The same rules apply. Why would I take her deposition when she hasn't finished her
Because the court
analysis?
ordered you to take her deposition because there were concerns about being able to have all of this done prior to trial. And you had concerns about what she was going to testify to. And the court set a scheduling order as to when, how, where, and the deadlines for those depositions to be conducted.
That prosecutor should have let me know. If he was going to ambush me at trial, I should have known beforehand about a new opinion that Dr. Warner was going to express, especially related to battered spouse, post-traumatic stress, and whether or not there was an imminent threat at the time of this event.
And the court's addressed that. Court did exactly what was required by binding precedent by the 6th District Court of Appeal and held a Richardson hearing. Analyzed the 3 factors as required by Florida law with regard to those and gave you the opportunity as a cure. And with regard to your request to strike or dismiss the case due to prosecutorial conduct, the case law by the 3rd District Court of Appeal filed April 10, 2024, State of Florida versus Denninghoff, Denninghoff, and I can provide you a citation momentarily, states that dismissal is an extreme sanction to be used with caution and only when a lesser sanction wouldn't achieve the desired result. Specifically, dismissal of an information or indictment is an action of such magnitude that resort to such sanction should only be had when no viable alternative exists. There were multiple viable alternatives, including but not limited to my request, an inquiry of whether or not you wanted that struck, and the instruction to strike that opinion, which you demurred and said, no, I want it for cross-examination. And I gave you the opportunity twice to depose her here in open court, which I oversaw with regard to any opinion that she based on the proffer or any other opinion that she would be offering today. For those reasons, the court is not going to exercise its discretion and strike due to the extreme nature of striking a criminal charge and for the adequate remedy that has been provided to you. Is there anything else, sir, we need to address?
May I supplement the record?
Yes, sir.
Judge, this deposition did not end on page 40 or 41 or 42. Mr. Owens took a direct examination of this deponent for 68 pages, and then it was turned over to myself for cross-examination during the deposition. Beginning on page 75, I asked the deponent, what did the defendant say about the murder? What she said on page 78 was that, starting at line 13, and she said there was a suitcase and some clothes that had gotten out to donate, and they were trying to get that together. And it was on the floor in the living room. And that, as she was coming down the stairs, she saw him kind of slipping into the suitcase as a hiding place. As she said, I saw him in the suitcase and I zipped him up and we were laughing. She said then he said he couldn't breathe, and I remembered feeling I couldn't breathe when he was choking me or sodomizing. And I was angry and I shook the suitcase. I lost control of the suitcase and it flipped. And she goes on and on about what happened. Defense counsel was there. He heard this testimony that there was no imminent danger presented at the time that she began getting angry, shaking the suitcase, hitting him with a bat, so on and so forth. And he didn't ask her that question after she had specifically instructed him, if you need an opinion of mine, you've got to ask me the question. It's unfair to experts to be thrown with this catch-all provision of please tell me any opinion about this case that you may think is relevant. Well, what the doctor may think is relevant is different than perhaps what counsel thinks is relevant. So it's really an unfair criticism of the state and probably more likely self-reflective that this deposition, this opportunity to ask about this obvious issue did not occur. So that is what I would like to supplement the record with. The deposition was substantially longer than page 41 or 42 where it's acting like it's concluding and, is there anything else? The state would just submit, I understand very well what my ethical duties are. I do not have any ethical duty to provide him an unrecorded statement that is not inconsistent with prior testimony. This doctor did not give me any unrecorded statements inconsistent with her testimony. Thank you.
Thank you.
Judge, I'd like to add on page 79 that Dr. Warner claims that Sarah said he put his 2 fingers out and I hit them with a bat. So there was rule of completeness, but for him to say that that's not standard operating procedure when you're taking a deposition of an expert.
Mr. Owens, I've ruled, sir. I understand. I understand your position. However, the questions that were specifically asked, which gave rise to this, specifically pertain to opinions of PTSD. I'm not going to rehash any and all of those things. The record speaks for itself. The court has ruled. Your motion for dismissal of the charges is denied. For the record, the citation that the court relied upon with regard to Denninghoff is located at 388 Southern 3rd, 10055, located at pinpoint 1057, Florida, 3rd District Court of Appeal, April 10th, 2024. With that, are we ready to bring back in our panel?
No, sir.
Okay?
Judge, I've got Earhart's Florida Evidence, 2023 edition, volume 1, Charles W. Earhart.
I've already, let me tell you how you're going to rule on this, sir. I'm going to allow you, as I said up here at sidebar, to go into the facts that she relied upon and what it is that she utilized. I'm going to allow you, sir, as I said up here at the bench before the lunch hour, to go into those opinions that she didn't offer here today. And on rebuttal, Mr. J, I'm not going to allow you to stand up and say, may I voir dire, that wasn't one of your opinions today. You can address all of that in redirect. Is that clear?
Clear to state.
Judge, let me just review to see if, because I had several.
What you had inquired of me, Mr. Owens, up here, was that you wanted to go into these other facts, medical records, text messages, statements, and you said, if I can't do it now because he's going to object, I'm going to call her and assert rebuttal. And the problem, as the state pointed out, is that you can't use her as a conduit to admissible evidence on direct examination. And that if you want to do it, you got to do it now. And your argument was it goes to her bias, it goes to her credibility, and that you're permitted wide discretion on cross-examination. I agree with you. I agreed with you before the lunch hour. My ruling hasn't changed. I'm going to absolutely allow you to go into those things.
I appreciate that, Judge. The other thing I wanted to readdress was,
I'm taking care of it, Counselor. Give me a moment. Yes, sir.
Judge, and I'm referring to Earhart's treatise, section 90.703, opinion on the ultimate issue. I'm on page 933. Testimony in the form of an opinion or inference otherwise admissible is not objectionable because it includes an ultimate issue to be decided by the trier of fact. And in that section 703.1, it talks about that opinion testimony is not inadmissible solely because it includes an ultimate issue to be decided by the trier of fact. The provision is equally applicable to expert and lay witnesses. The jury has the power to accept or reject the testimony of expert or lay witnesses and is not bound by their conclusions. Merely because a witness expresses an opinion to an ultimate issue does not compel the jury to find the facts to be true. The jury will be given the opinion. The jury will give the opinion as much weight as it feels the opinion deserves. Then it goes on. The abolition of the rule against opinions on the ultimate issues does not mean that all other opinions are admissible. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case. Witnesses will be prevented from expressing their conclusions when the opinion only tells the jury how to decide the case and does not help the jury to determine what occurred. For example, a witness cannot express his or her opinion as to the guilt or innocence of a criminal defendant. And I'm on page 940. 703.1 still. When a witness is asked to express an opinion that applies a legal standard to a set of facts, which Dr. Warner did, the opinion testimony is generally inadmissible. The danger is that the witness will apply a standard or definition which is different from that defined by the applicable law. The application of erroneous legal standard results in the opinion testimony being misleading and not helpful to the jury. For example, An expert cannot opine whether a nursing home was negligent in its care of the decedent.
It's exactly what we spoke about at council's table.
I know, Judge, but if you go on, it says an expert may not be permitted that a truck driver drove in a grossly negligent manner, whether the sheriff's conduct was unconstitutional, whether certain waters are navigable, whether the defendant's action constituted misapplication or concealment of funds, or the legal obligations of the parties to a contract, whether the testimony of the expert is a permissible factual conclusion, or the impermissible application of a legal standard or definition to a set of facts is sometimes a fine distinction involving a large measure of discretion with the trial judge. For example, the admission of expert testimony that certain investments, it goes on. However, the witness expresses an opinion about the intent of the accused. The opinion, this is one of the important sections. However, if the witness expresses an opinion about the intent of the accused, which Dr. Warner did, the opinion has not been permitted. The distinction drawn by the courts as to when this type of opinion testimony is admissible are often not clear. Section 90.703 does not permit a witness to testify to legal conclusions or express an opinion upon questions of substantive law. This expert testimony regarding substantive legal principles may not be helpful to the jury and may create confusion if an expert testifies in a manner that is different or even in conflict with the testimony of an opposing expert.
But the citations, respectfully, Counselor.
Judge, if I could finish.
Respectfully, Counselor, the citations that you're referring to are not at issue. Fluellen, error to permit arresting officer to testify that a quantity of cocaine possessed by appellant indicated that he possessed with intent to sell, which is a specific element of the charge in that case. Gamble, officer's expert testimony with the amount of drugs found in defendant's possession was inconsistent with personal use and therefore intended for sale was inadmissible. 644 Southern 2nd, 1376 for Gamble, and Fluellen, 703 Southern 2nd, 511. The Dinkin case that I read says this is acceptable. If a psychologist or psychiatrist can testify that someone is not mentally defective or was mentally defective, that's on all fours with, based on what the defendant had said to this expert, she was not in imminent fear. Now, I don't remember exactly what was said, but it was along those lines, based as looking all those things, the totality of the circumstances of what, in my evaluation, on or about October 2, that the defendant had said to me as the expert, it's not imminent fear. That opinion is not inadmissible per the case law under Dinkins.
Judge, can I read a little bit more?
If you're just going to be reading from the treatise, I've already read it.
Okay, well, I just want to make mention, because it's talking about does not prevent a witness to testify about legal conclusions or express opinions on questions of substantive law. And I was about to finish this section when this testimony, and I'm on page 947, this testimony may also interfere with the function of the trial judge to determine the applicable law and to instruct the jury thereon. As we know, we're going to do battle over the jury instruction on justifiable use of deadly and non-deadly force. The testimony from Dr. Warner, and I wrote it down, she said based on what Sarah Boone told her, she was not facing imminent risk of harm. That invades the province and function of the trial judge to determine the applicable law and to instruct the jury otherwise, which we haven't even done yet. You haven't made findings of law about which instructions apply. That's what she did, Judge.
Your objection's been made for the record, and the court previously ruled on this matter. I appreciate the additional argument, but the court's reliance on Dinkins remains.
Thank you.
Just because 9703 speaks for itself. So your objection is overruled as to that issue. Anything else we need to address, Mr. Owens, before we bring back in our panel?
No, sir.
State?
Nothing, thank you, Judge.
Okay, let's bring back in our panel.